I'm Michael Tabman, and welcome to Crimes and Times. Thank you for joining us after our little break from last week. Tonight, we're going to look at a case of a man who's been in prison since 2004 for a robbery that I and some others are just not convinced he committed. The case of wrongful conviction is something we've seen as a phenomenon throughout the United States, and more than 2,000 people have been identified over the last some odd decades as having been wrongfully convicted. And that's just people we've identified through DNA and other evidence that come to light. How many more people have been wrongfully convicted for a number of reasons? Tonight, we're going to discuss the case of Carl Leeper. He was arrested in 2004 for robbery. He is still in jail, and his time to get out, I believe, is 2024. We're joined by his wife, Angel. Angel, thanks for joining with us tonight.
Hi.
And we're also joined with John Humphrey. John comes from a lineage of prosecutors, right, John? You had a father-son team working for a while. Is that correct?
That's correct. My dad was a part-time prosecutor in Jackson County, state of Missouri, for over 45 years. And for 6 of those years, I was also a prosecutor, and we got to try a number of cases together. It was a blast.
So you have a DA in your DNA, so to speak, right?
That's correct.
Yeah, that's a good one. I came up with that out of nowhere.
All right.
Yeah, now sometime during the show, folks, Carl is going to try to join us from prison on the call. When that comes in, we'll interrupt our show here and have him join us. Again, that's always very questionable as to whether he could get to that phone or not. So let's see what happens. But here's what we have. In January of 2003, a Priscilla's store in Wyandotte County was robbed. Is that correct? It was 2003, Angel?
Yes,
Right.
yes, that's correct.
John, are you familiar with the Priscilla's chain of stores?
Yes, I am. Yes.
Okay, it's an adult store, and I'm happy to say I did not know what a Priscilla's was. Okay, but now we know what it is. All right, a Priscilla's was robbed in the evening in Wyandotte County. Later that night, and there was no arrest made. Later that night in Overland Park, another Priscilla's was robbed, and the Overland Park police made an arrest. So we had 2 Priscilla's robbed the same evening. The Wyandotte County detective, I guess it was KCK police, drove out to Overland Park to interview or get a picture of the Overland Park suspect. All right? So the second robbery went down. The Overland Park police went out there, got a picture of that suspect, created a lineup, and then went back to the witness in KCK and showed her that lineup.
Correct.
All right. From there, the witness, we'll call KF, we won't use any names, the witness KF picked out the person who was the suspect in the Overland Park matter. All right.
Correct.
All right. After that, the police, on their own accord, the KCK police ruled out that suspect as committing their robbery in Wyandotte County.
Correct.
My time is correct, right?
Yes.
Okay. So
Other than the fact that they said that the robbery happened in late, it was like 4 o'clock in the afternoon. So it was earlier in the day that the first robbery happened. The second robbery happened in the evening. And then I believe it was the next day whenever they went to the jail and got the photo lineup made up for the victim.
Okay. But we know, right, and we know that she picked out a suspect, and he was later ruled out. So, John, I'm going to ask you to make a little mark in your head about that identification.
So
okay.
They made an identification. The Overland Park Priscilla's victim looked at a photographic lineup.
No, the
KCK
right.
victim looked at the suspect from the Overland Park Priscilla's robbery, who had been arrested.
Correct.
And Wyandotte County ruled that suspect out as a suspect in their own robbery.
At a later date, correct.
After she identified.
On what basis?
We can never find out. They would not cooperate. And despite all my tracking down of records through my own search and lawyers, we could not find the records of that arrest. But we don't know, and the police department would not talk to us. But they ruled out an individual called MW because we never did identify that arrest as the suspect in KCK. Okay? But the witness KF did pick out that suspect out of the lineup. So, again, mental note there. So that would be the end of it. But months later, Carl is arrested for that robbery, and how many other robberies, Angel?
8 other robberies.
8 other robberies. So
9 total.
Right. Let's tell the audience what happened. So in those preceding months of that, a man by the name of Pat Brake, who was Carl's cousin, right?
Correct.
Gets arrested for one of those robberies, one of these 9 robberies. And he cooperates and he tells the police, hey, let me tell you something. It wasn't just me, but my cousin Carl helped me with these. And specifically, the robbery of the Priscillas and KCK, Pat says, I waited on the outside, Carl went in, and he committed the robbery.
What is
have that correct. Okay? Based on that, the police put together a lineup with Carl's picture, and Carl has a record. Let's put that out there. Carl has a record, right? Okay?
Yes.
They put out a picture with Carl in there, and they had not yet ever interviewed Carl, right?
Nope.
Nope. So they go out there now. This is their second lineup a few months later. They go back to the same witness, KF, show her that lineup, and she picks out Carl.
Yes.
So now, John, I'm looking at your face, John. I had to look away. What strikes you, John, as a former law enforcement officer like myself? What's the first thing that strikes you there?
It's ridiculous. I mean, the ability of a witness to recall, and the jury instructions are clear on this. Whenever there's identification testimony offered in a criminal case, at least in Missouri, the jury instructions are very clear. And they tell the jury that you are to consider a number of factors when evaluating the credibility of eyewitness testimony. Number 1, the proximity of the identification to the event, right, tends to provide more credibility for identification. Conversely, more time having expired since the incident will tend to lessen the credibility of identification. And here, we have already had positive identification within 24, 48 hours of the suspect. For some reason, the cops rule that it's inaccurate. They undermine the criminal justice, undermine the fact-finding role, be it a judge or a jury, in determining that identification was correct. And then 2 months later, for some reason, on a snitch's word, they snatch up Carl, go back to the witness, and you and I both know, Michael, as former law enforcement, that there are very probably subtle techniques to convince a witness to pick the guy that we have circled. So anyway, it's extreme regulation.
Right.
Yeah.
Yes, and that was the first thing that struck me. One, how often, in your prosecutorial times, do you hope that the witness even picks him out the first time, the suspect the first time? Never mind twice in a row, and then be the wrong one. It makes you think again. What were the subtleties of that lineup that made the person pick out the police suspect both times? Now I'll tell you this: I did interview that witness, KF, and she's a very nice woman. No intent to harm anybody, but she was very, very confused as to what happened. And as a matter of fact, during the trial and during my interview of her, she never remembered having made 2 identifications. She only remembers having made 1. So we had a witness. I'm sorry? Yes.
So she remembers the only identification she made being the one in which she picked Carl?
Correct. She didn't remember making a wrong, identification. That has to, make you think about things. Now, so moving along, so Carl went to trial on these other 8, Angel, right?
Correct.
What were the results of those 8?
He got found not guilty of 8 aggravated armed robberies and not guilty of felon in possession of a firearm. They got found guilty of an aggravated armed robbery and got 221 months, 18 and a half years. Mm-hmm.
But just for
the Wyandotte County Priscilla robbery.
Yes, where there was misidentification, shoddy police work, all those things. It was, it's a railroad.
Right. And
it's a railroad.
Was Cousin Patrick a co-defendant in these, or were they tried separately?
There was a total of 3. There was 3. They separated there was 3. 2 co-defendants and Pat. Pat implicated not only Carl, but one of Carl's friends, and then recanted his statement.
Right. Yes. So just for John's edification, clarification for the audience. So what happened was Carl and Pat had a fight. And they were just mad at each other. And Pat will later say that's why I implicated Carl out of revenge. And
Because Carl beat up his brother. Yes.
right, that was the other thing. And again, just, so everyone knows, Carl, as we know, he's no virgin to getting in trouble. But the question is, did he do this one? Did he do this crime? That is the key thing. So, and John, as we would tell you, we tell the audience, if there was a prosecutor sitting, next to us, they would have another, interpretation of, these facts as well. And we know that. We're only presenting sort of our side, so much slanted as can be. So, Pat did try to recant his statement. He came to court one time during a hearing, and he gave us a very strange explanation. He said that Carl's attorney told him to plead the fifth. We never got to the bottom of that. We never figured out why that happened. I interviewed Pat, which we're going to show that interview in a little bit, and Pat said that's what happened. That makes no sense to any of us, but we don't know why it happened. But since then, Pat has been trying to recant it, and nobody's listening. So I interviewed Pat, and we're going to play that interview. Max, we can have that ready. I'm going to play that interview for the audience, and for John, I want you to look at it. And Angel, I know you've seen it, and it's quite emotional for you. But let's go ahead.
It makes me cry every time.
We know that eyewitness identifications are routinely inaccurate and lead to wrongful convictions.
I'm not hearing any
I
audio.
interviewed that witness. Hold on. Angel, and it was clear that that person.
I don't hear audio either.
Hold on.
Did not wish to cause anybody harm,
Max,
but that witness to me appeared very confused. That witness.
Right, and these are the live issues we have every now and then, and we'll try to fix them. And I said I'd beat up my engineer afterwards, but he's way too big for me. So I'm going to try again. While he's working on that, we'll go on to something else here. So.
We know that eyewitness identifications are routinely inaccurate.
Hello, you have a call at no expense to you from
Carl. And it was clear that that person is a very
at
Kansas Department of Corrections, Lansing Correctional Facility.
To accept this call, press or say 5. To refuse this call, hang up now. To block this call and all future calls, press. This call will be recorded and subject to monitoring at any time. Thank you for using IC Solutions. You may begin speaking now.
Hello, Mr. Tab. Yes, sir. How you doing? Yes, sir. What happened when I was arrested? First off, I had beat my cousin up for stealing my truck. I thought that the police wanted me for that. I wasn't ready to go back to jail, so I took off. They found me in Missouri and brought me back and charged me with 9 aggravated robberies. And I found out that it was my cousin's brother, Pat, that had implicated me or give the police my name and somebody else's name as the people that committed these robberies. And they convinced 2 young women to point me out in photo lineups like 4 months after the robberies. Yes. Yes, sir.
Hello.
Non-violent. They're burglaries. That's it. Well, because I'm actually innocent. Like I said before, I've done some things in my past that I'm not proud of, and I was through with all that. I was doing what I was supposed to do while I was on parole, and I got heated. It wasn't about the truck. My brother had went out of town and left his kids' money in this truck, and my cousin was supposed to be house sitting for him, and he hot-wired the truck and put switch tags on it, so I was pretty upset. That's what happened there. I'm not a... Yeah. Yes, they did, but I didn't have anything to give them, so, yeah. Yeah, yeah, many times. I mean, no, me and my wife Angel, we've thought about it. It's just so hard to remember. It was so long ago, but I'm almost positive. I mean, we always stayed at home. If I wasn't working, I was at home. Pat Brake? Did he tell me that? No, he did that at our prelim. And yeah, I didn't have a clue what he was doing, but he had told his lawyer that he wanted to get on the stand and testify, and that's when I found out that he was sorry and that he tried to tell him the truth. So, yeah. Yes, yes. Yes, yes.
I am. Yes.
My lawyer, as far as I've seen, didn't do none of that. Not none of it. I mean, I was taken to trial on 4 counts of robbery, 1 count of felon in possession of a firearm. The first robbery, count 1, the victim couldn't identify nobody ever, but there was a witness there that worked there. And she's the one that identified me by my eyes only 4 months after the robbery. So they split that robbery and made it count 1 and count 2 and took me to trial on it. And then the third robbery was a Mexican. He owned a Mexican store right like 2 or 3 houses away from where Pat Brake lived. He identified Pat Brake at our prelim as the man that robbed him, but they bound me over for trial on that. And then the 5th one, yes. Yes, sir.
I would be inclined to take a step back, yes. And the common thread in all of these cases to tie Carl in was Pat Brake, right? Now, the lady that, Carl, are you saying that the case in which you were identified by your eyes only, is that the Priscilla's Wyandotte County case?
No, that was the Quick's barbecue case, the case that I was found not guilty on. They took me to trial on all those cases at the same time.
Okay. And so then the one in which only Pat was identified, but you were bound over, you were acquitted of that one also?
Yes, sir.
Okay. Michael, I mean, from a prosecutor's perspective, just at that phase of the case, on that one where Pat was identified, but Carl was bound over, I mean, that makes sense this early in the stage of the game, because Pat admits that he was involved and he names a co-defendant, Carl. And so when the witness identifies Pat, it corroborates the first half of Pat's story that Pat was involved in the robbery. And the prosecutor could rightfully at that point believe that Carl was a co-defendant suspect. But your question is, when these dice start falling down, don't you want to question whether or not Carl is good for any of these? And the answer is absolutely. It should have happened. And Carl, I don't, did you have a public defender on these?
Yes, sir, I did.
By and large, public defenders get a horrible rap. And that's because generally they get to spend very little time with their clients because of their massive caseloads. But I can say, clients used to come up and say, are you a public defender or a real lawyer? And most of the public defenders that I know are not just real lawyers, they're real good lawyers because they have more experience. Now, Carl, in a case like yours where there are so many charges against you from different crimes, I can see where a public defender with an insane caseload might not be able to afford your case, each of the separate 8 cases, and the combination of them all, the time that was required for justice to be done. And that's a sad state of affairs everywhere. And the state of Missouri is actually on the cutting edge of trying to modify this, of trying to reduce public defender caseloads and improve budgets for the appointment of more private attorneys. But yes, I think your lawyer should have gone to the prosecutor and said, look, case number 1, fail. Case number 2, fail. Case number 3, fail, etc. All of the cases in which Carl is charged because of Pat Brake's snitch are falling apart. Certainly you see there's a common thread of incredible testimony.
We know that eyewitness identifications are routinely inaccurate.
Michael, I'm just
and lead
seeing
to
your
wrongful conviction.
profile picture.
I interviewed
Am I supposed
that
to be
witness,
seeing the show live?
and it was clear that that person was a very kind person, did not wish to cause anybody harm, but that witness to me appeared very confused. That witness still did not remember that she had made 2 separate identifications from police lineups.
I
Shortly
see.
after Carl's arrest,
Angel, you're
Pat Brake tried to recant his accusation of Carl. I have spoken to Pat Brake, and he has confessed to me on videotape as to having been the only person to have committed that robbery.
Hi, babe.
He has stated once again that
still
Carl
there?
was not involved in any manner,
Hello?
and that he, Pat Brake,
Hi, honey.
committed the robbery alone. The robbery of the
Hey, baby.
Priscillas,
Yes.
January 25th, 2003.
you guys are on the air.
By me.
And only you,
Only me.
Carl Lieber, is not guilty.
No.
And you're willing to swear to that in front of court?
Yes, sir.
Are you willing to be interviewed by a law enforcement officer?
Yes, sir.
And you're willing to be polygraphed?
Yes, sir.
Max, if you're there, Michael, I can only see your profile. I cannot see the show itself. Okay. No, that was it. I wanted to see what was going on the broadcast.
The audience. One is Casey asks, do police really push for a lineup to end up with a predetermined outcome? John, you want to take that one as a former prosecutor?
I can tell you that when I was 2 or 3 years into the prosecutor's office, and this was before the advent of surveillance before the proliferation of surveillance cameras, a guy who was a prosecutor before me and went into private practice willed to me about a dozen big framed black and white photographs. Many of them were surveillance videos of armed robberies in which the robber was clearly identified. But among these pictures was, and I know you've probably seen this, it's almost cliche now, there's a lineup of 6 guys, and there's 2 cops holding one of the guys, like they've just beat him up and they're holding him up and they're saying, can you identify any of these witnesses? And so while that is rare, suggestive lineups are rarely that obvious, usually they're more subtle. Usually the suggestion to a witness on behalf of the law enforcement officers is more subtle, and Michael, you'd be able to better speak to it. I don't know how they do it, but they can say, they may have shown them an individual picture of the suspect before they show them a group lineup.
Right. Hey, Carl, you still there?
Yes, sir.
Okay, we're going to have to hang up on you because the stream is interrupting the rest of the broadcast. But anything you want to say to the audience, Carl?
Thank you. And about this lineup, it's quite obvious in my case that the police pointed me out in the lineup. All you have to do is read the case, and you can see that for yourself. And thank everybody for listening, and hopefully maybe I'll keep praying, and maybe somebody someday will help us.
And we hope so too. We hope so too. Angel,
Mr. Tabman, I want to thank you on behalf of my family and myself. Thank you, and God bless.
Okay, Carl, hang in there, buddy. All right.
Hang in there, buddy.
Thank you.
All right.
All right, we're gonna let Carl go. So that's just again, CNN. We ain't. We have only so much bandwidth we could work with there. We still have everybody online. Angel, you still there? Lost Angel. John. All right, I'm going to answer questions, and Max is going to get our people back. So the question is, do police really push for a lineup to win with a predetermined outcome? Police go in there with good intent. I still believe that, most law enforcement officers want to do the right thing. But we go in there with blinders on that because, yes, we want things to be a certain way. We have this prejudice. But we also believe we're right. And I can tell you, during my years in law enforcement, I always had the attitude, I'm doing the right thing. Everyone else is doing the right thing. We can't be wrong. We're not being biased. But police and law enforcement can, very subtly, as we've talked about before, make certain gestures, certain motions, certain statements, not even aware that they're doing it, to push people in a certain direction. So we know that eyewitnesses are generally unreliable, not because they're necessarily lying, just because of all the mental and cognitive biases that could get in the way of making a good identification. So, John, I was just, while we had lost you there for a second, I was following up on your statement, about the foibles of lineups and how witnesses could get manipulated in a certain way, whether the police mean it or not. A certain way, their inflections in their voice, the way they react to the person's response. How can someone mess up a lineup? Just from the way we talked about. Certainly, there's intentional ways, and we hope we don't see that. But sometimes they're, sort of sub rosa under the radar. They don't mean to do it, but they're out there so anxious to make the case that subtly they sort of give these hints to people. The next question is, how can a guy get convicted for a crime if he was exonerated on the others? John, let me just answer that quickly, then I'll let you take it. But basically, because each charge stands on its own. John, do you want to make any other statements about that?
No, and I agree with that. I hate to put all the blame on whoever's Carl's lawyer was at the time, but you're right. Each count does stand on its own. And just as you can't use a person's criminal history in a trial against them to demonstrate their propensity to commit the same offense, likewise, their innocence of a string of crimes doesn't mandate that they're innocent of the crime with which they're charged.
Right. But again, as you and I just said a few moments ago, we'd hope that certain intangibles, such as 8 cases falling like dominoes, might give them reason to pause and say, hey, maybe we do have the wrong guy. We're not making this case. Now, the next question really fits into a good part of what the rest of the show is going to be about. The next question from Ajik asks, any physical evidence? And Angel, I know you want to answer this one yourself. I've got the information right here, John. We're going to bring you in on it. But Angel, why don't you tell them? Because I know that's something that just gets to you.
The only physical evidence that they said that there was a videotape of the robbery, which showed the perpetrator come into the Priscilla's, look around without a ski mask on, go out, and then come back in with the ski mask on. I mean, where's the videotape? They never produced it at trial. Not for the jury, not for any of us. None of us.
There was one more thing.
They said they lifted fingerprints. No fingerprints. Now it's lost. Everything's lost in police evidence. And it's our place to produce the burden of proof. How are we going to do that? We can't get into a police locker to get a videotape that's been gone for 14 years now. 14 years?
And they never did present these fingerprints at trial, right?
None of that. Nothing ever.
Okay, I want to bring up, Max, you bring up this draft here from the transcript, this first one here. Did we confirm, if someone could just Skype into us, confirm if you did hear Pat Brake's confession, if you were able to hear it. Someone could just Skype into us. I'm sorry, tweet into us, let us know that the audience heard it. Okay?
Okay, good.
All right, so here's a document we're all looking at, folks. You may not be able to read it, but the point is to show you that this is a transcript from the tape. Okay? So, John, I want to get you in on this. So this is the prosecutor talking to the witness, KF. All right, did you tell the police at some time, at some point, that there was a video in the store? Yes. Okay, and have you ever had an opportunity to review that? Witness, yes. Okay, there's the prosecutor. And is the gentleman or the suspect on the video? The answer is yes, ma'am. Okay? The witness is saying that she saw the video and was able to identify the suspect, in the words of the prosecutor, who was Carl.
Is this trial? Is this a trial transcript or
Yes.
deposition?
Trial transcript. Angel, I'm right on that? This is a trial transcript?
Yes,
Yep.
those are trial, probably
Trial
preliminary trial transcripts, but
Okay.
yes.
All right, preliminary hearing? Okay.
Okay. And now we have the same prosecutor, I believe, asked a question to the detective, the investigating detective. Were you able to discern, and this is page 2, Max, I just want to show everyone that it does exist, okay? Were you able to discern the face of the robber from that video? And the detective says no. John, prosecutor, lawyer, what are you thinking?
All right, so the first video,
No, one video.
Angel, right, the video, which Angel referred, it showed the man come in without a ski mask, right? And then went back out and came in with a ski mask. How do we know it's the same person? Because of the clothing?
No, she said that the man came in, looked around the store, then walked outside, came back in, and was touching videos, pulled down the ski mask, and then came to the counter.
Okay, so she saw him do this. Okay. And this is on their own surveillance video, which was obviously provided to the prosecutor because he asked the question in preliminary hearing, and were you able to identify the witness from the video? Or he asked the witness if she was able to identify the robber from the video, correct?
Correct.
And then when questioning the officer, the prosecutor asked the officer if he could identify the suspect in the video, and the officer couldn't.
Right.
No.
What do you make of that, Michael?
We have some, what I call some irresponsible prosecution, in my opinion, John. At that point, in my opinion, the prosecution should have sit back down and said, this is not a good case, but they move forward. What's your thoughts?
Well, it seems like it's prime pickings for reasonable doubt when you get it to a trial.
You would think so. You would think so, right? And I want to make a point, John, to you.
Where's the video? Where is the damn video?
They never showed the video.
That's what I'm saying.
If they had a video that showed him on there, John, isn't that the first thing as a prosecutor you would show?
It's the first thing I want as a defense attorney.
Well, if he's not on there, exactly. But if
It
he
was
is
in
on
our
there,
motion for discovery. It was never produced with the motion for discovery from the very beginning. It's been wrong from the inception of this case. From its inception, it has been wrong completely.
Now, with regard to the fingerprints, the absence of evidence is not evidence itself. I mean, if there were fingerprints at the scene that were lifted, I mean, A, how do you know they belong to the suspect, right? Unless a witness is saying that location was only touched by the suspect. And then if there are fingerprints there and they've been submitted for analysis, who do they match or not match? You know, a lot of times they will come back with a report that says there was insufficient, the fingerprint, they didn't have enough identifying markers to make a match. But now with computer technology, still, the absence of the video shrieks of a gross miscarriage of justice.
yes,
Like
it does. Right, because again, as a prosecutor, if you have someone on videotape committing the crime, wouldn't you say, look, everybody, look what we have here? How would that not be the first thing you do as a prosecutor?
And the state has an absolute affirmative duty to provide that evidence, whether it's punitive or exonerative. It doesn't matter. They have to do that. In fact, Jackson County has gone
To find
through
the truth.
Jackson County went through some growing pains within the last decade about allegations of, evidence withholding and not. So they have a policy that if you walk in there, their file is open. Everything they have, you're entitled to look through. And they make a concentrated affirmative effort to make sure that you get every single piece of evidence, even as it comes in throughout the investigation.
Right. And John, going back to those fingerprints, even if they were inconclusive and they didn't match Carl, that is potentially exculpatory that they have to turn over to the defense, don't they?
Yes. Oh, they have to turn over everything, whether it's exculpatory or not.
Right. Now, one more thing I want to, Max, well, we don't have to put it up. I'll just show the group I have it. This is another part of the transcript. This is the prosecutor speaking, John. I want to get your opinion, a statement she makes. After she asks a question, then she poses another question. She states, okay, I seen the video now. And when he got into the store prior to robbing you, he was in front of the counter and bent down, is a question. But she makes a statement, I seen the video. As a prosecutor, doesn't that now make her a potential witness?
Where's this statement from?
The same questioning of this witness, of KF.
In the preliminary hearing.
Angel, this is
no, those were the trial transcripts, I believe.
Yeah, I think these are the
trial.
Yeah.
I see the video now. I mean, she could only have said that if the video was introduced. Am I wrong?
That's why I'm asking you, prosecutor. That's what I would imagine. It sounds like now she's testifying to evidence that was never brought into evidence.
I see the video now. I mean, that's unambiguous. I mean, I'm thinking like she's looking up on like a little kid's DVD player and watching it herself, but not sharing it with the rest of the group. I mean, I see the video now.
I think it was just more colloquialism. I've seen the video now, and I think just more just common language conversation. But she's saying that she's seen the video, so she's actually testifying as a witness to evidence that the video which they never brought in.
Yes.
Well, what they said was that the judge, the prosecutor, and the public defender all saw the video, but the identification wasn't clear enough to bring it in as evidence.
John,
how are you going to? That's what they said. That the evidence, that the video wasn't clear enough to bring in as evidence.
Oh, so there might have been some pretrial powwow in chambers where they all looked at it and the judge made a ruling to not admit it. Well, I mean, that's just bad juju, bad judiciary juju, bad prosecutor juju, because the finder of fact, whether it's a trial to a judge or to a jury, the finder of fact, in this case the jury, absolutely has to be the last stop for the admission of that evidence.
Right.
Okay. Very good. All right, we got a bunch of more. We have a huge audience tonight with a bunch more questions coming in. The first one asked about any physical evidence. I think we discussed that. Can multiple charges be heard at the same time? John, any prohibition on that on the state level? Yeah.
No, absolutely not. No, you can be charged with robbery, armed criminal action, sodomy, rape, murder, all at one time.
Okay. Pork Soda asks, only one person on the video, not two. But I think, Angel, it's fair to say we don't know because no one's seen the video. So we don't really know what's on the video. Again, someone asked the question, the quality of the video, the surveillance video. We don't know. The police and the prosecution never, ever produced this video that one person, the witness, says, oh, I've seen the suspect, and a police detective says, I couldn't make him out. I don't know how you move forward on that kind of evidence. Next question. It seems like when they get a video in court and the cop can't ID the guy, how can that not be dismissed? I think, John, that's the big question here, right?
Exactly.
I think we have some, what at least I would call a prosecutorial, at least misconduct, maybe not on the legal scale, but certainly on the ethical scale, in my opinion. John?
Definitely.
Yep. Okay. I'm still shaking my head about this.
Okay. No video, no prints. How can this not have been thrown out? And I think we're all, and I want to make something clear to the audience, and John as well, because an Angel knows this. I've never stood in front of anybody, because I've gone to a prosecutor with this, and I'll discuss that in a moment. I've never said Carl's innocent. I never said I know for a fact he didn't do it. What I'm saying is the state never proved their case. Beyond a reasonable doubt, I don't think they have sufficient probable cause here, John, to arrest him. Never mind find him guilty of this thing. We just didn't prove our case, and that's all I'm saying.
Well, probable cause is pretty easily had. I mean, if you remember taking your cases, I mean, if a snitch says the guy did it with me, yeah, that's enough to get him arrested. But even at the end of a jury trial, a judge can make a finding that the finding by the jury of guilt is against the manifest weight of the evidence, and the judge can take that verdict away. That rarely happens, but it also sounds like it would have been the right thing in this case.
Yeah, but if you know, again, going a little beyond just the prima facie of Pat's statement, if I'm a cop and I'm looking at this video that just absolutely stinks, and then I got Pat recanting, and then I have look at all these other wrongful identifications by my key witness, I'd have to say, I don't have a case here. I don't think I would have moved forward. Okay, someone asked, multiple people could have prints on the adult video. Yeah, that's true. Yes, we understand that. But again, when the police say they collected fingerprints, as John correctly pointed out, they're obligated to turn the results of that analysis over to the defense, irrespective of the results. And the last question we have, the attorney should have shut down anything about evidence being referred to that isn't admitted into evidence. I think, again, John, that goes to the defense attorney being able to challenge things. Okay. So, John, with all this done, I have Pat on tape. I understand you didn't see it. Our audience did. We have Pat admitting to it. We have all these issues that we just discussed today. So about a year and a half, 2 years ago, I went to the Wyandotte County District Attorney's Office, and I met with one of their chief investigators, not the DA himself, and there's a new DA elected since then. And I asked them to please revisit this case based on everything we discussed here. And the investigator says, well, what do you want me to do? I said, what I would like you to do is this. We have Carl and Angel who say they were home during the robbery. They are willing to be polygraphed, at least say that Carl said he didn't do it. We have Pat Brake who says he did do it, and he's willing to be polygraphed. And I'm saying, why can't we just have all three of them polygraphed? And if all three pass, certainly consider the fact that we may have the wrong guy in jail. So, of course, his answer to me, and he's former law enforcement, he says, well, Michael, you know that this is not admissible in court, polygraphs. I know that. But, John, you know that we worked the polygraph when we wanted to work the polygraph. When we wanted to guide our investigations a certain way, just like when a child disappears or someone disappears, we say, oh, the parents are cooperating, they've submitted to a polygraph. We know it's not conclusive, but we use it as a lead. So, John, is there anything wrong in view of everything of asking the prosecutor's office, the DA's office, to at least give a polygraph to these people and review this case?
No, I don't think there's anything wrong with asking them to do a polygraph, but Angel and Carl, Carl said last night, we think we were home, but it was so many months before, we don't know for sure. So, I'm kind of concerned of how their polygraph would turn out when questioned about where they were on that night, because I think even now they can't say for sure. But Brake's statement that I did it, polygraph him. See if he's telling the truth. And I don't even think it requires a polygraph. I mean, the guy's coming forward. He's putting his own butt on the line for a crime that he knows he's good for that could, further incarcerate him.
But
that's enough.
But even if Carl just, you try to limit it down. Carl, did you rob the Priscillas? No. And he passes the polygraph. Shouldn't that in view with or in line with Brake's polygraph be somewhat persuasive, wouldn't it?
Michael, well, not just that, but I think if you put those two things, Carl's polygraph and Brake's statement, and the whole list of screw-ups that took place during the trial, just all the evidentiary screw-ups, the preliminary investigations, the preliminary hearing answers, I think that is plenty sufficient to warrant, well, a court to give him a habeas corpus. Come back and see what the heck happened here.
Yeah, John, just FYI, since you're a defense attorney, I imagine after this you're going to get a lot of calls. So, expect that coming based on what you said here. Another question, a polygraph doesn't mean anything, can't use it when you want to get a conviction, can't use it when you get exoneration. Ronald, that is correct. But in law enforcement, we do use it often to just help us direct our investigation, help us decide what we want to believe and not believe, and steer in that direction. So if both people passed a polygraph, you're correct. We could not get an exoneration on that, but it would give rise for the district attorney to at least review this case. And as John said, in light of everything else, think maybe we have the wrong guy in jail, and maybe we need to revisit this. Look, Angel, how long has Carl been in jail?
He's been in jail since March of 2004. That's a long time. That's 14 and a half years. 14 and a half years. His out date is April 1st of 2024.
John, for a robbery when no one was hurt, that sound excessive to you?
Well, it depends on the county. In Jackson County, those kind of crimes where there's no physical injury. It just depends. It depends on how outraged the jury is. And in this case, I want to go back to the polygraph, Michael. You have sat through many of them. I have sat through a couple of them with clients. Folks, this is not an on or off red light, green light. This is, the polygraphers have to be incredibly well trained. and they have to be able to interpret the data they're getting based on the responses of the subject. And they take hours and hours and hours. And when a subject comes out of the polygraph, usually they're sweating. I mean, it's a grueling experience. But as Michael said, they give you direction at which way to go. And I have never seen a polygraph that I thought was inaccurate. You know, I went in thinking my client was going to pass with flying colors off the hook. He came out sweating, and they said he indicated deception. And it turns out they were accurate.
Right. All right, another question came in. Can you directly go to the governor? I get, John, we could always ask the governor for a pardon, couldn't somebody?
You can always ask the governor for a pardon. In fact, Jeff Collier stands to be our next governor, and I may text him and ask him to do just that.
There we go. Look at that. Make some goods come out of that. And another question. You do not have any way to challenge the fact an attorney did a terrible job. There are ways, but there's a lot of limitations. John, could you answer that question as well?
Yes. When a case goes to trial or is pled, and the person is sent to prison or put on probation, well, when he's sent to prison, when his sentence is executed, the judge, at least in Missouri, has exactly 120 days within which the judge retains jurisdiction over the case. So when you hear about folks getting a 120-day callback, that's why the 120 is a magic number, because after the 120 days, the court no longer has any fingernails in that case file. It's gone. And the client, the defendant, then becomes basically the property of the Missouri Department of Probation and Parole, and they get to do whatever. So we come back 2 years later and say, judge, this case is all screwed up. This guy's innocent. Witnesses are lying. The judge is like, I can't help you. You know, it's out of my hands. And that's why we have these writs like Angel and Michael we discussed, I think, before the show. You ask a federal court to grant a writ of habeas corpus. Give us the body. You know, this person is being unconstitutionally detained. And that's, I think, where you're heading right now, isn't it? Isn't that what you're working on right now, habeas corpus?
Angel?
Yes, I'm sorry, you guys are a little bit quiet right now. It's kind of low on the volume. I can't really hear you. But yes, we are in the habeas corpus stage right now in the federal court.
Okay. All right, Angel, just so you know, my engineer tells me we're getting flooded with tweets that are not questions, but a lot of sympathy for your situation and concern that Carl was denied a fair trial. So, Angel, we're going to sign off soon. Any last words for us in the audience?
I'll just never stop fighting. My life is my husband and my kids and my grandchildren now. I have 5 beautiful grandchildren. I mean, it is what it is. I'll be here when it gets out, whether it's next week, next year, 2024. I'm not going anywhere.
Hang in there, Angel. We're working for you. John.
Thanks, everybody, for listening.
Thank you, Angel. John, final words, and if you want to tell people where they can reach you, because I'm sure a lot of people may want to reach you after this show.
816-333-2000. No, my words are, don't give up. I have great faith in our criminal justice system. I've seen it do a lot of error, but I, for the most part, believe it's the best on the planet, and that all of the participants are really well-meaning.
All right,
well, thanks, John. Hey, feel free to send any referrals my way.
All right, guys, you were 2 terrific guests. Thank you so much. Thank you for the audience. You had some great questions. The tape we showed earlier is on change.org. Go there, look up my name, Michael Tabman, T-A-B-M-A-N, or Carl Leeper, L-E-E-P-E-R. Please sign our petition, and please feel free to express to the Wyandotte District Attorney's Office your belief that this case needs to be reopened. Again, please like us on Facebook. Please go to YouTube and become a subscriber on YouTube. Click that little button. Once we get a certain number, we'll be able to stream this on other platforms. We have a growing audience. We had a tremendous audience tonight with some great questions. Thank you, everybody. We appreciate all your time and support. I'm Michael Tabman, and thank you for joining us in Crimes and Times. I'll see you next week.